Hello to everybody. This is Maria Hauser-Morel. It is now time for the debate. The topic of our today's debate is this House believes that a presumption of arbitrations without hearings will make arbitration great again. And we have two excellent speakers, and I hope that they will soon join us. Hello, Noah. Hello, Patricia. And our two excellent speakers, they need absolutely no introduction. You have their bios in the brochure, but just very briefly, Dr. Patricia Shaughnessy is an American in Sweden. She's an arbitrator, counsel, and Noah knows where I'm getting, of course. And she's also created the famous Master of International Commercial Arbitration in Sweden. Patricia, we're very happy to have you. And against her, we have Noah Rubens, QC, an American in Paris, counsel and arbitrator and specialist, and very active in CIS. He's leads the Freshfields CIS Russia Dispute Resolution Group. So welcome to both of you. And so we have today an interesting debate between the two of you. This House believes that the presumption of arbitrations without hearings will make arbitration great again. And before the two of you start the debate, we propose a poll to our participants. And how it works is that you should either scan the QR code that appears on the screen or follow the link and vote. And we are to wait for some 1 or 2 minutes, and then the results should appear on the screen if I got it right. So we are waiting. Okay, we have one vote for now. We're still waiting. I don't know if the organizers see if the voting is still pending. Otherwise, I would announce the preliminary results. Okay, unless I hear objections from the organizers, the results from the first poll is that no is the majority. Now, I no longer have the results on my screen, so I think it was 11 for no. Yes, very well, Noah.
Phew.
I can hear you.
I'm like going,
I don't know if the others can.
Okay, maybe I was screaming over you this whole time. Sorry.
That's what you usually do, don't you?
That's true. That's a good point.
Sorry, I no longer have the result. Yes, very well, Patricia. So I no longer have the debate. It was majority was no, but I think it was 11 for no and 6 for yes. But I don't have the results on my screen. But now it's time for the debate for today. And of course, it's a debate. So the views expressed by Patricia and by Noah are mainly for the purposes of this debate. So we have to remember that. But for the purposes of this debate, Noah will be for and Patricia will be against. And the structure of the debate will be that each speaker will speak for 7 minutes. Then afterwards, there will be rebuttals 3 minutes each, and then we will take the poll again. So Noah, as you are for, I let you begin. And you
Thank
have
you.
7
I do hope that
minutes.
everyone can hear me. That was a little broken up. Can you hear me?
Perfectly. Perfectly
Can you hear
well.
me okay? All right, great. All right. We are at an existential moment, my friends. We are at a crisis of arbitration, a crisis that is caused by a violation of the very fundamental expectations of the parties who choose arbitration. Arbitration has always been a trade-off. It was never intended to be a full quest for justice at any cost. Otherwise, there would be appeals on the merits. There would be 6-week hearings like there are in the High Court in England. And nobody wants that. But the trade-off for partial justice needs to be reconsidered because we have lost the upside. What we're supposed to get in exchange for no appeals and so possible mistakes and so on is savings in cost, savings in speed, and a legitimacy born of the agreement between the parties. And I put to you that that is no longer the case. We have multiple 100-page briefs being submitted with dozens of witness statements and massive costs of counsel and an escalation of massive submissions where really very little would do, where issues even in cases where the issues in dispute are quite simple. And part of that problem is the assumption that there is always going to be a hearing. Hearings involve a massive preparation cost. It ties up the clients, it ties up their counsel for an extended period of time, as well as the arbitrators for that time. In my personal experience, up to 1/3 of the total cost of arbitration is incurred in the run-up to and during the hearing, as well as after the hearing, to the extent post-hearing briefs are required. That's with respect to cost. With respect to time, there's no doubt that the endless extension of time for the issuance of awards is partly because in every case, pretty much, there's a hearing. Because first, to find the block of time that everyone can, all of the arbitrators can accommodate and the parties and their counsel can accommodate, creates dead space in an otherwise condensed schedule. And that can double the total length of time of an arbitration. And the drafting of an award cannot begin until after the hearing has been held, and even if there's post-hearing briefs after that. And of course, all the material that was presented during the hearing has to be also taken into account in the award. At least it has to be mentioned, and that also adds to the time. And so you get months and months of additional time before awards are issued. And what for? Well, the main purpose of a hearing in arbitration is to hear witnesses. It's not to repeat the same arguments that were made in writing at length. And a great many commercial disputes involve no witnesses. Even for those cases, the presumption is that there will be a hearing. And the vast majority of cases, including those with witnesses, aren't decided based on what the witnesses actually say. Just think of the civil courts, for example, in places like Germany or France, where there are no hearings, there are no witness, there's no witness testimony at all, even in the most complex and important civil disputes. No one says that that deprives the parties of some fundamental right. Any civil judge will say, well, ultimately, the witnesses, when they come, they say what's good for their side. You can't trust them anyway. And so bringing them in front of a tribunal only confuses the issues. It only creates the opportunity for dissimulation, for false statements, and for distracting the tribunal from what's really important. There's also an even more nefarious point, which has to do with diversity, which has to do with unconscious bias. It's at the hearing that the tribunal can be subjected to their unconscious prejudgments about people's ethnicity, their national origin, their gender, their age, whether it be counsel or the attending representatives of the party. And that is an extremely nefarious thing, which does not come into play when cases are heard on the merits. Now, let me make clear, nobody is saying to eliminate hearings. Just shift the presumption. The presumption against hearings is already in place in fast-track arbitration. And what I'm saying is that this can have, shifting that into normal track arbitration can have a positive impact where on the margin, a great number of unnecessary hearings will be avoided. The cost and time of those hearings will be avoided simply because the parties will have to think twice as to whether it's necessary. Discretion will always remain with the tribunal, and in appropriate cases, the tribunal will hold the hearing. So 3 reasons: cost, time, and legitimacy all point to a presumption against oral hearings in commercial arbitration. Thank you.
Thank you very much, Noah. You haven't even used up your whole of your time.
Excellent.
Patricia. Patricia, it's now your turn.
Thank you, Madam Moderator and Mr. Rubens and all of our esteemed colleagues who are listening today. The premise of the proposition, which Mr. Rubens has so eloquently presented, fails. So consequently, the proposition falls with it. The idea that arbitration needs to be made great again implies that somehow its greatness has been lost. That is simply not the case. Mr. Rubens paints a picture of a crisis. There is not a crisis. There is an evolution of arbitration expanding its toolbox, and it's expanding its responsiveness to the users. There is no evidence that users want such a presumption, and indeed the evidence points to the contrary. The evidence points to arbitration is great and getting increasingly better. The main features of arbitration, which have promoted it and made it the trusted preferred method for resolving business disputes, would be undermined by the proposition which is proffered by Mr. Rubens. The flexibility, the effectiveness, and yes, the efficiency, and yes, the lower costs, the fairness, and the respect for party autonomy would be thrown under Mr. Rubens' bus, driven by arbitrator discretion, without any directions to the parties as to how to overcome the burden of such a presumption. Now, indeed, there are many problems which this proposition would introduce, and I will come to that. But first, I would like to explore a little bit the failure of the premise. Mr. Rubens has helped me by noting that there already exists arbitration suitable for documents only, fast track, low value, less complex disputes, expedited arbitration procedures. And indeed, UNCITRAL Working Group 2 is nearing the conclusion of its work on proposing such features to be included in the UNCITRAL arbitration rules. Parties already can, and very occasionally do, subject their disputes to various documents-only arbitration by agreeing to expedited procedures or to rules which will trigger those procedures, or by putting it into their arbitration agreement, or through procedural agreements. Indeed, already the Chartered Institute of Arbitrators produced a documents-only procedure protocol, which parties can use if they would like. The UNCITRAL rules and Article 27.2 provides that this could be something the parties agreed to. And indeed, the UNCITRAL model law in Article 24.1 provides, subject to any agreement of the parties, the tribunal shall provide hearings as appropriate. The ICC Commission's widely read document on controlling times and costs provide in Section 35 that this is something which can be considered by the parties of the arbitrators, and it's included in the ICC's Appendix number 4. The tools are there if the parties want them. What Mr. Rubens is proposing is that there would be a presumption of this on all arbitrations, whether or not the parties agreed. And this would be to strangle the right to be heard, and it would be to harness and restrict party autonomy in favor of discretion of the arbitrators. It would throw the balance off. Let me quickly respond to some of the problems that we'll raise, but let me notice that arbitration hearings are not dead space, and to many parties, they're a valuable opportunity that parties want to have to witness, to see, and to hear the administration of justice in their case. The parties may not always only want to pay lawyers to make extensive submissions, which the parties do not find particularly easy to comprehend. They want to see the arbitrators in the eye. They want to hear what is being said in the proceedings. And for those who don't, there are the tools already available to have documents only. I would suggest that the approach of the Hong Kong International Arbitration Center in its Rule 24.2, I believe it is, that provides for, on the request of a party, an arbitrator can consider documents only, not a presumption, on the request can consider, is a good balance to approaching when a hearing is necessary or not necessary. We do not need, and indeed, the presumption that is being proposed would have serious problems. One, unlike what Mr. Rubens projects, it would likely increase written submissions because now everything would need to be in writing. There would not be an opportunity to meet with the tribunal, to have questions posed and easily answer them during the proceedings. Instead, there'd be written questions and written submissions and counter submissions. The whole process would become writing heavy. There would be witness statements, and those statements would have to be cross-examined in writing. Again, more writing, more legal fees, and less opportunities for the parties to feel that they're able to participate in the justice system which they're financing. And by the way, as the lawyers are writing all of this material and the arbitrators are reading all of it, in the ad valorem system, the payments would probably not be any less, but for the arbitrators, you wouldn't have to go to a hearing. You'd still have to write the award. There would be serious potential enforcement issues because indeed the model law and most modern arbitration acts provide for the right to a hearing, be it live, in person, or remote. This could raise particular issues about due process. And it would be contrary to user expectations. As mentioned, we have already the tools, and we don't see them, except in the fast track cases, being used. It arguably would favor civil law
time is
jurisdiction.
Up. It's time to conclude, Patricia. It's time to conclude.
I have so many more arguments. I'll save them for the rebuttal.
Thank you. Noah.
Thank you. Well, we see the difference in approach between the academics and the practicants in terms of the use of time. I do put to you that there's a crisis in arbitration, and anyone who has seen the inflation of costs and the complaints of clients will understand that there is something broken here. Now, my learned friend has presented a straw man to you. It has nothing to do with what I'm proposing. I'm by no means proposing to do away with hearings. I'm simply proposing to shift an assumption. That means there will still be many, many hearings in many, many cases. And such things, as Professor Shaughnessy has pointed out, happen all the time in fast track. And so this idea that national arbitration laws somehow prohibit or will not recognize an award where there wasn't a right to a hearing, I think is a fallacy, because we know that fast track awards are entirely enforceable around the world. That is not a problem. I also think that this idea that focusing on the writing rather than on the oral advocacy would somehow increase the writing. I don't think that's true at all. On the contrary, this idea that one can throw anything at your opponent during a hearing, regardless of what was written, is what increases the complexity and the unpredictable nature of arbitration in the first place. I'll also say that my learned friend has not, perhaps for the want of time, been able to address this issue of unconscious bias. When one looks another person in the eye, there is a problem. And for an academic, it should be clear. The prevalence today of blind examinations, for example, where the professor does not know the skin color or national origin or class or the way a person speaks. is seen as a fundamental part of fairness in the academic circles. Why not in arbitration? With that, I will conclude.
Thank you, Noah. Patricia.
I'm all for inclusion, and I'm all for trying to avoid unconscious bias. But I don't think you're going to eliminate it by eliminating hearings, Noah. There's still going, excuse me, Mr. Rubens, there will still be witness statements, and the witness statements will indicate the age, the occupation, where the person is, their name. It will indicate a lot of information which could trigger completely unjustified biases. So you're not going to eliminate, they're not going to be secret witnesses who don't have an identity or background, who are not subject to some kind of check. And it's going to make it very difficult for those cases where there may be conflicting interpretations of the important documentary evidence or conflicting factual issues where there are very little documents and may favor civil law lawyers who have a greater documentary record in which to draw upon. That was pointed out by Paula Hodges in an article already a decade ago on this topic. Importantly, arbitration requires trust. And it requires trust in the tribunal and trust in the process. If users want this, then they would put it into their agreements. They can already use it. And I don't think it's fair to compare fast track arbitration expedited with complex cases. And importantly, I think one must bear in mind that it's not just public policy that may be an unruly horse. Arbitrators can be an unruly horse, and the reins on them is party autonomy, party agreement. And if we shift to a presumption to apply in all cases, that will mean that a party who is arguing against not having its hearing, live or remotely, will have to convince the arbitrator that that presumption has been overcome. And where is that presumption going to be embedded? How will it be implemented? Who is going to provide some kind of control over the discretion of the arbitrator to eliminate the hearing? Will it be in the rules? Do you suggest putting it in legislation? How are you going to make it compatible with the right to a hearing, which is embedded already in instruments throughout the world? This is a bad idea that will bring bad problems. If people, clients, parties want to go documents only, there already exists opportunities to do that. So I think it's better to sell it in the particular case where the circumstances justify it and the parties want it, rather than strangulating arbitration with such an onerous presumption. Arbitration is not litigation. It's private, paid for the parties, by the parties, and it is a one event, a one hearing opportunity.
Thank you, Patricia. Thank you very much to both. Now let's see who has convinced our viewers and listeners. You should soon have the poll, the QR code on your screens. And we will do the poll again once it's there. It could also appear apparently in the comments on the YouTube channel. This has been, there it is. So either you use the QR code or the link in the comments. So for or against the presumption of arbitration without hearings. And that will make arbitration great again.
Well, you got the tough argument. I thought you did a terrific job of trying to something.
Yes, absolutely. I thought it was, I mean, we could debate for forever, but it was super interesting.
I'm not sure we're going to have changed any minds on this one. Maybe.
Might be. We're neck and neck right now. We weren't before.
Yeah.
You may have won, but you changed our mind. See, you're winning, Noah.
Oh.
How about that?
Don't influence them, Patricia. Don't influence them.
No. Is it the same total as before?
I think it was the diversity argument that won.
Okay. Is it over? People are shy to vote.
Is the total the same as before?
I think before it was 11 plus 6, wasn't it? I can't remember. I didn't note it down.
I lost in a big way.
Okay.
And now it's, I can't see.
Equal almost. Yeah. Okay.
And the same total? Almost the same total.
Almost.
Cool.
I think that's it, guys. Oh, no.
Oh, you got one. You got one at the end there. Someone felt sorry for you.
We were here trying to change minds.
It's super interesting. I mean,
excellent.
So the end result is 8 yes and 8 no's. So it's quite equal. Thank you very much. We still have 4 minutes. So Noah, Patricia, any follow-up comments?
Yeah. I mean, the interesting thing, of course, is I totally agree, Patricia, that you need to provide people what they want. And the suggestion is not, of course, that you impose this on everybody, but that you would incorporate it in a certain set of rules, which would otherwise be normal rules, not fast-track rules, but they would have a presumption against live hearings, right? A presumption, and then you could say discretion be exercised based on such factors as, complexity, like the need to cross-examine witnesses, all that kind of stuff. And then you have that on the shelf as an option for people to incorporate into their contracts. I mean, it just wouldn't work to say all arbitration is going to be on an assumption that there's no hearing. But it would be interesting. Then you could test the presumption, that you could test the thesis that people want this, right? And the idea is, I think that a lot of hearings happen because counsel are used to it and they convince their clients that it's necessary, and they think they get some advantage from it. Whereas ex ante, a client itself may say, do we really need that? If they're told that it's going to cost, say, a third of the total cost is a hearing, and maybe we don't need any witnesses, and if we do, maybe it'll be uncontested, and I don't know.
Yeah, but one of the potential risks, who knows, might be that if that started to work its way into rules, instead of it being an option embedded into different guides and things, is an option to consider for some or all issues, not to have a hearing or to consider that. But then if it became a presumption, parties might start putting into their arbitration agreement that they have, that they want to have a hearing in order to get out of the presumption. Sure. And then you may end up with a real problem that is in the arbitration agreement, and then discretion when you get to an actual dispute is actually limited so that the effort to create the presumption could backfire.
Well, I presume that people would rather than putting into their contracts a complete override, they just reset the presumption. They'd repeat, for example, the ICC rules, which say the tribunal, if one of the parties requests a hearing, there will be one. Which is what the ICC rules say, right? So, presumably if that's what you want, but you otherwise want these rules, then you'll just put your contract, notwithstanding Article so-and-so of our rules, if one party wants a hearing, they will have it. Because for now, there is no discretion in the ICC.
That's kind of the Hong Kong approach. That's kind of the Hong Kong
approach. In the ICC, there's no discretion.
Yeah. Under ICC, there's discretion with expedited. Under expedited procedure, the tribunal can decide not to. Although in majority of cases, even in expedited, the tribunals it still do the hearing, even if one party says it doesn't want to. So if the one party says I want a hearing, my experience is that arbitral tribunals do a hearing.
Yeah. SEC rules are the opposite. They say that the hearing will be an exceptional.
Yeah.
So it doesn't make a presumption, but it says with the expectation, if you read the rules, your expectation should be that it would be exceptional.
Yeah.
Well, guys, our time is up. I was super happy. It was a privilege and a pleasure to spend half an hour with both of you. Thank you very, very much, Patricia. And thank you, Noah, for this debate. Have a lovely afternoon. And it's now time for the next session moderated by Artem Dudko. Thank you very much to all.
Thank you.
Thank you, Maria.
Thank you. Thank you.